Supreme Court Review, MS Simplex Infrastructure Ltd v. Union of India. On 5 January 2006, Simplex Infrastructure Ltd, a well-regarded contractor, entered into an agreement with the Union of India, represented by the Executive Engineer of the Central Public Works Department, CPWD, Andaman Central Division. The agreement tasked the contractor with constructing 821 permanent shelters in the tsunami-affected areas of the Andaman and Nicobar Islands. Disputes over the contract's execution led both parties to arbitration. On 27 October 2014, the arbitrator ruled in favor of Simplex Infrastructure Ltd, directing the Union of India to pay 9,96,98,355 rupees with 10% annual interest from 1 January 2009 until the payment date. The Union of India formally received the arbitral award on 31 October 2014. On 30 January 2015, the Union of India filed an application under Section 34 of the Arbitration and Conciliation Act, 1996, before the District Judge, Port Blair, to annul the arbitral award. However, the District Judge dismissed the application on 12 February 2016, citing lack of jurisdiction as per Section 42 of the Arbitration Act. Notably, an earlier application pursuant to Section 9 had been filed before the High Court of Calcutta, in turn binding subsequent applications to the same court. On 28 March 2016, the Union of India filed a fresh Section 34 application before the High Court of Calcutta. Alongside this filing, they sought a condonation of delay amounting to 514 days. The Union of India attributed the delay to an honest error in filing in the wrong jurisdiction and bureaucratic obstacles in securing essential approvals. The High Court on 27 April 2016 justified this delay as a sufficient cause and moved forward with the case. Simplex Infrastructure Ltd, dissatisfied by the High Court's decision, appealed to the Supreme Court. It argued that, even when excluding the time wasted in the initial wrong court filing under Section 14 of the Limitation Act, an additional delay of 131 days had accrued, making the application inadmissible under Section 34(3) of the Arbitration Act, which strictly limits such delays. The Union of India countered this argument by citing administrative challenges, particularly delays in securing permissions. They emphasized that the appeal was filed in good faith without malicious intent. The Supreme Court scrutinized the statutory timelines prescribed under Section 34(3) of the Arbitration and Conciliation Act. The section stipulates that an application to challenge an award must be filed within 3 months from receipt of the award, with an optional extension of up to 30 additional days provided that sufficient cause is demonstrated. Delays beyond this permissible window are absolutely barred. Drawing on precedent, Union of India vs Popular Construction Company, 2001, 8 SCC 470, the court stated that Section 34(3)'s limitations cannot be overridden by Section 5 of the Limitation Act. Furthermore, while time spent litigating in an inappropriate jurisdiction could be deducted under Section 14 of the Limitation Act, that alone could not rationalize an additional 131-day delay. The court concluded that administrative delays in obtaining approvals do not meet the threshold of sufficient cause. Ultimately, the Supreme Court overturned the High Court's condonation of delay, ruling the Section 34 application time-barred. The arbitral award in favor of Simplex Infrastructure Ltd was upheld, reaffirming the sanctity of statutory deadlines in arbitration. This judgment serves as a critical reminder to legal practitioners and scholars about the mandatory nature of limitation periods under Section 34(3) of the Arbitration Act. The decision underscores the judiciary's firm stance on maintaining the finality of arbitral awards, ensuring that procedural compliance is strictly observed. Administrative inefficiencies, however bona fide, are insufficient grounds for disregarding statutory deadlines.